1171 of 2023, Public versus John Maina Njenga, Daudi Mwangi, Daniel Mugwe, Simon Mugai, John Kuria, Peterson Wanjao, Samuel Kangebe, Julius Ndungu, Peter Njenga, Philip Kagiri, Peter Njoroge, John Muriu.
Your own appearances are in the morning. Yes. Yes, Your Honor. The quorum is as it was in the morning. Yes. Okay. Yes. Your Honor. Aaron Ndubi, Ondieki, Ndewa, Njiru, Gitari, John Maina, Cheche, Ntoni Mburu, Njoki Mburu,
Steve Biko,
Mugure,
He's not taking
Rex Nyambura.
It's not as before.
Yeah, maybe some people have delayed, yeah. Yes.
Present.
Yes.
Yes, I'm present. Yes,
Mr. Cheche. Mr. Cheche.
Cheche.
Mr. Gitari. If I'm not wrong. Yes.
Miss Nyambura.
Miss Nyambura. And Miss Njoki Buru for the accused persons.
Your Honor, for the prosecution, we have Ms. Mburu, Mr. Ruto, and myself.
Section 204 of the Criminal Procedure Code provides, quote, if a complaint at any time before a final order is passed in a case under this part satisfies the court that there are sufficient grounds for permitting him to withdraw his complaint, the court may permit him to withdraw it and shall thereupon acquit the accused person. End of quote. The sixth schedule on transition and this is the sixth schedule of the Constitution on transition. Quote, all law in force immediately before the effective date continues in force and shall be construed with the alteration, adaptation, qualification, and exceptions necessary to bring it into conformity with this Constitution. End of quote. The application and the responses revolved around the above provisions. For clarity and as a way of distinction, the last amendment of the present section 87A was in 2012. This was way after the effective date of the Constitution, hence any alteration, if intended, would have been introduced at the subsequent amendment. Testing section 210 under the present position, it is instructive and unequivocal that section 210 of the Criminal Procedure Code only relates to circumstances after the close of the prosecution's case, which is not the case herein. Section 204, on the other hand, relates to withdrawal of complaint by the complainant. As is the practice, such withdrawal is only made on oath, which is not the case here. What then is the recourse under the circumstance? As pointed out, the provisions the prosecution sought to employ withdrawal of the case herein under Section 87A of the Criminal Procedure Code. The end result is not in contest, that it result, if allowed, to a discharge and does not bar subsequent charge of the accused person on account of the same facts. This is not a termination of a case per se. The case would remain alive and at the whim or discretion of reinstitution by the prosecution. The case shall remain hanging on the neck of the accused person. The accused person shall live in perpetual fear of rearrest and reinstitution of the charges on similar facts. In deciding whether or not to allow the application, the central principle to be borne in mind is whether the threshold have been met. In exercising discretion under Section 87A of the CPC, the court must satisfy itself that the threshold for grant of such order is demonstrated. In this case, the prosecution has outlined 4 grounds as espoused above. The ground revolves on insufficiency of evidence to sustain the charge. As it stands, according to the prosecution, the charges as they are bare and unsupported. In the absence of the evidence, they find difficulty in procuring. 9 witnesses have testified as listed in 4. It is upon reviewing the evidence recorded so far that the prosecution deemed it necessary to discontinue the prosecution of the accused for insufficiency of evidence under Section 87 of the CPC. The defense on their part, as much as they do not object to the determination of the charges, or the view that to bring closure to the matter, then acquittal would suffice. This charge, according to the defense, is prone to misuse and act that would infringe to the accused person's right guaranteed under Article 50. I agree with the defense that discontinuance of the matter under Section 87A of the CPC would not bring closure to the matter, as it shall remain an active sword that can be swayed by the prosecution at their whim. The prosecution, on their part, maintain that it is not in possession of sufficient evidence capable of sustaining the charge, and deem it proper to discontinue the same at this stage under Section 87A of the Criminal Procedure Code. The prosecution cites its inability to avail crucial witnesses to prove the charge, and as it stands, the charges against the accused person are not supported. The prosecution is silent on its potency to reinstitute the charges should the application be allowed. Taking a cue from Mr. Biko's submissions on proper utilization of the court's time, of what use would be to the court to sustain a charge admittedly not supported? What would be the party's cost implication of attending to a trial whose evidentiary content is known and admitted to the prosecution? It is a non-trial in my view. Unsustainable trial, and sustaining the same would be, by extension, entertaining the abuse of the process of the court. In as much as I sympathize with the accused persons who have been subjected to this admittedly unnecessary trial for over 18 months, the only available recourse would be to allow termination of the case under Section 87A of the Criminal Procedure Code. This court's ruling is explicit as to the admission by the prosecution of its ground for termination of the case, that is, the account of lack of evidence. Admission that the prosecution does not possess sufficient evidence to sustain the charge, to sustain any of the charge against any of the accused person. In the end, I allow the prosecution's application to withdraw the charge under Section 7A of the CPC. Each accused person is discharged accordingly, and I direct that the cash bail deposited by each of the accused persons in court be refunded to the respective depositors. Those are the orders of this court.
Well, Your Honor, we highly appreciate the ruling of the court. I don't think on my behalf and behalf of my clients and perhaps my fellow defense counsel, we wish to thank the court for the time it has taken, the resources it has expended towards this trial, and the patience within which the court has accorded to all the parties. We highly appreciate, and should there be a recommendation to a higher bench, be assured that I shall be one of the referees. And as such, Your Honor, and on behalf of my clients once more, allow me to wish the court a Happy New Year, a Merry Christmas, and Happy New Year.
Your Honor, I made a request for the forms before you came out. I need those forms, Ms. Oye has not business with them anyway. And the shortest time possible, if possible, close the business today. Unless they are elsewhere, those forms should have been here. There are also exhibits on the floor. Those exhibits also be released accordingly. There are poles, those are farm tools, the equipments. We do request that they be returned to our hands. All the things that were called paraphernalia be released to them. This court has since handed down its pronouncement to the matter. And we thank you so much.
May I participate in boring you? We are very thankful for your patience. You have suffered us with grace. May I also thank the prosecution for the courage to admit to the insufficiency of evidence. It is not always, like I said earlier in the morning, we have had a history, and that history doesn't speak too well, but now I can see that we are making a turn, we are on the bend to getting to a better place. I would like to thank the court too for the reason that even in the morning as it's raining outside, you were sufficiently gracious to arrange for another sitting place for members of the public who had often come to participate in these proceedings and see what's happening. So our prayers for good health for both you and our clients who have given us the privilege to represent them. It is not everybody who gets the privilege to represent the likes of Daudi and all these fellows who you may not know, or the first accused who is notoriously known as a patriotic Kenyan. So we are grateful, Your Honor, and may I, as I sit down, say thank you, but as I conclude, we are requesting that we are supplied with a certified copy of the proceedings and this ruling for posterity. This is a ruling, a decision, notwithstanding that we disagree with the outcome, the end result, but I think it is quite sound it would take us time to reflect and possibly recommend amendment to the CPC, that 87A, to deal with it conclusively, so that this willy-nilly decision by some officers to charge people and then come and say, sorry, we did not conclude on the investigation, should stop. And lastly, and this I am not addressing the court particularly, but to ourselves as Kenyans, and more especially the police officers. I was shocked to hear from the prosecution that the police officers who were rounded up from different jurisdictions did not keep a record of themselves plus the arms they carried. Your Honor will recall, and this is probably off record, that our theory has been that they planted some things on, especially the first accused. What stops any police officer from planting things if they can carry arms from their stations, walk away without a record? No wonder Kenyans are being abducted by people who are not on duty, and the officers senior to them don't know. And you may want to be reminded, especially my colleagues from the prosecution. There was a police officer who was caught in Nairobi collecting bribes from motorists when he was on duty, or he was off duty. He was on leave, and he was actually posted to Makueni. That is the kind of behavior, the laxity that we are seeing in our police service. May I call it a police force, because they have not discipline in their mind, but they are service. But this police force, which is supposed to be a service because that's what we expected in the new constitution, they need to reflect and change their behavior. And lastly, for my friend Njenga, I will take tea outside as we leave. He should be reminded politely that those, what did you call those, the guidelines, the decision to charge guidelines, they are not law. That's not the statute. We base our decision to charge on the Constitution and the penal code. Thank you, and have a good day, everyone.
Just one word, because my colleagues have said it all. Your Honor, I've spoken because I have tremendous respect for this court. Your Honor, you are the embodiment of judicial efficiency, judicial humility, and judicial appreciation of the public. Because this was a difficult case. But the way you have handled it, you have made us proud. I can actually say that the CID, the DCI, the officers are innocent. The DODBP officers are innocent. These were orders from above. And I think, thank God, the top crumbled. And after the crumbling, so the substratum upon which these churches were premised collapsed. So the reality has dawned that there is no case, because the purpose for which the case was being pursued no longer subsists. And I'm not ashamed to say that this was a politically motivated case. And I thank God that our officers, the DCI and the DPP, have acted properly by appreciating that this was a mistake. This country has to move forward. This is a rich country. There is everything for all of us. There is no need of fighting. There is no need of hating each other. And there is no need of being greedy, because you can't eat a whole drum of food. You only need a handful. So, Your Honor, with those values, I think Kenya can move on. I really take this opportunity to thank you, and I appeal to the CCA. If there is those promotion on merit, then this is one court that should be promoted on merit. Yes. Yes. I rest my case, Your Honor.
Only one more thing. We would wish to teach lessons to the police officers, so that once they take instructions, they take legal and execute legal instructions. I'll be seeking instructions from my client to take personal actions against the IO, Mr. Misoi. And as such, Your Honor, I apply that you order I be supplied with certified proceedings and the ruling for today, I'll personally take actions against you.
I'm conflicted. This one is my plan.
You'll defend him.
Your Honor, just like my colleagues have said, mine is just to wish you the best, and surely you deserve, you are fit for the bench.
Just one or few sentences. Your Honor, it is obvious that this application was brought on two grounds of fear. Fear that the accused persons reserve the right to sue the state for harassing, threatening, and all manner of things. Such that when they walk out, then there will be fear on the part of the accused persons to sue the state. We still have that right to sue the state. Secondly, in order to instill fear that the moment they walk out of that door, they will be rearrested. Those are the two fears that they had. We hope this application was brought in good faith, such that the moment they walk out, they are free men, but reserving the right to sue the state. All the best for you, Your Honor.
Your Honor, final remarks as the prosecution. This is a court of law as well as a court of justice. The law has been followed and justice has been administered. Thank you.
Say something.
Make a rider, if you can allow me to make the rider. Your Honor, all the experts should return to the accused except the branded ones. The gun, yeah, we need to be sure about that.
Mr. should keep his.
Yes, each stakeholder should keep their experts.
And they can make use of the tobacco.
The tobacco we leave to Central Kenya, hiyo ingine tupeleke Nyanza.
Yes, following the post-ruling sentence and application, I give the following directions. The court's proceedings rulings to be paid and certified, and it should be made available to the parties. The items recovered from the accused, particularly the forms, be released to the accused persons forthwith. The release shall be through the IO.
We must start.
very much.
We're most obliged.
Thank you.